Hey everyone, welcome. I see we've got about 14 people, 24. Nice. We're going to let people fill in. You've come to the right place. The handsome devil to my left, your right, is Jon Hyman with his coronavirus haircut.
Never been more happy to be bald in my life. The past 6 weeks. Holy cow.
Welcome everyone. If people can hear us okay, just throw a comment up there. Checking the volume. Seems like everything's all right, but we're going to give this a minute or so to fill in. Hello to you, Michelle. Nice to see you. Hello, Wisconsin. Shout out, Wisconsin. All right. Oh, nice shirt. You talking about me?
Yeah, decision in terms of what T-shirt to pull out of the drawer every morning to go to work.
That's right. That's right. I think yesterday I had on a Taco Bell T-shirt.
There you go.
Yeah.
I've been saving my Kool-Aid Man T-shirt for special occasions. I should have worn that one today.
Oh yeah.
Oh yeah.
Hello from Montana. Nice. Greetings from Arkansas. All right. Looks like people can hear us fine. People are rolling in. That's good. Well, we might as well get started. We want to be mindful of your time. Welcome, everyone, to the Friday, our return to Facebook Live. Last time we did Zoom, the Factile Zoom, which worked out pretty well. We didn't have any Zoom bombers. We only had one little bit of technical difficulty, but we got through the Factile game pretty successfully. And welcome back to the Employer Handbook Facebook Live. My name is Eric Meyer. I am an attorney, an employment law attorney at Fisher Broyles. That's Fisher Broyles, BROYLES.com. I'm also the publisher of the Employer Handbook at theemployerhandbook.com. You guys probably already knew that. Most of you probably know my special guest. But special guest, why don't you introduce yourself and tell everyone a little bit about yourself?
I feel like I should have had like a curtain or something to reveal myself, but here we'll do it there. There we go. Howdy, everyone. I'm Jon Hyman, partner with the law firm of Myers, Roman, Friedberg, and Lewis in Cleveland, Ohio, and also the longtime author of the soon to celebrate its 13th anniversary Ohio Employer Law Blog. And I am very grateful to be with my friend Eric today. And thank you so much for the invite. I really appreciate it.
All right. So someone's saying they can barely hear John. I don't know. I got my volume cranked up as far as we can go. Let me see if I can put this on speaker. I don't know if there's a way to do that. And maybe that'll, can we do that? Is that possible? I don't know. I think we are on speaker. I think that's the best we're going to get.
Testing.
I hear you.
Better?
I hear you fine. So we'll do the best we can. Well, folks, welcome to our Friday Facebook Live chat. We'll probably go about this for about an hour. If you're running to overtime, it is what it is, and if we cut it short, then we'll cut it short. But I assume most of you have questions that hopefully we can provide some non-lawyerly advice in answering. In fact, let me dispense with the standard disclaimer. Please pardon the coronavirus haircut. Maybe you should have gone with the hat today, but that's okay. That's not really the disclaimer. The actual disclaimer is that John and I are lawyers, but we're not your lawyers. And if we are your lawyers, we're not giving who put giants 5 exclamation points in the comments? Get out of here. Yeah, get out of here. Get out of here. We are lawyers, but we are not your lawyers. And if we are your lawyers, we're still not giving you legal advice today. This is a day on which, when we provide advice, we're doing it as it's hypothetical. We assume all your questions are for a friend. And if any of you are tuning in today to get legal advice free on a Friday in a Facebook Live chat, you got problems. Really, what you should be doing is calling up your lawyer and spending good money to do it the right way. So no legal advice here today. I got a couple things on my little agenda here to my right. First thing I said to everyone that I want to start off with today is an FFCRA. I don't want to go through all the minutia and recap, but I want to ask you, John, how are your clients dealing with it at this point? We're 30 days in, or more than, well, no, today is the 30-day anniversary, I guess. It went into effect on April 1. Here it is, May 1. How are your clients dealing with the FFCRA?
I think for the most part, they're dealing with it okay. We had the initial wave of confusion when it was enacted and where I was working, 15, 16, 17-hour days, answering questions, getting information to my clients in terms of what their responsibilities were. I think by and large, they've gotten it sorted out. And I'm surmising that by just the number of questions that have the number of questions has decreased over as the month has gone on. And so I think from their perspective, they kind of figured out the initial confusion in terms of what they had to do, what they needed from a policy standpoint, the information they needed to collect. And now the questions are coming in on a much more pointed kind of employee by employee issue, as opposed to kind of macro level, like what does this mean issues. So it seems to me like people are kind of seem to be managing it okay, at least on the macro level.
What were, if you don't mind sharing, what were some of the common client questions, or the most common client questions that you've been getting all along?
We got a lot of questions about documentation. In terms of documentation they had to keep, what kind of notice they had to be, what kind of notice they had to provide. We got a lot of questions at the beginning of, so-and-so is afraid to leave their house to go to work. Does this mean we have to pay them for their time off? That's a no under the FFCRA, but check unemployment on it. Those were, we got a lot of questions about remote work in terms of, how do we manage this with remote work? If someone can work remote, does this mean that, we do pay them, we don't pay them? And then just by the nature of my practice and a lot of clients that we service, which are tend to run on the smaller side, we had a lot of questions about the small business exception and how that applies, and whether, what a client with 40 employees can declare self-exempt, how they do that, what it means, what provisions they're exempt from. And so that was the small business exemption were probably half the questions I had right out the box from my clients.
Okay. I've been seeing more and more recently the interplay between FFCRA and unemployment. So, can someone collect both? Again, hard no. When should you pivot into furlough? And if someone's getting paid time off, can they collect unemployment compensation at the same time, even if it's not FFCRA? And I don't know all 50 states, but I know locally that's a pretty hard no as well.
Yeah, here in Ohio as well.
Yep. So those are the issues that I've been seeing, at least most recently. And John, I'm seeing a lot of the I'm afraid to come to work, or not just I'm afraid to come to work, but folks who want a really long time off from work. Not just the, let's say, maximum of 12 weeks that you would get if you were taking the expanded family medical leave, but want longer than that. Folks who envision that they're going to have to care for their children throughout the summer because school ends, but I think we know now, just because school ends, that doesn't mean that someone's not going to be potentially eligible to get that expanded family medical leave because there's no alternative childcare, so to speak, over the summer.
Yeah, which is a legit issue as states start returning people to work. Like here in Ohio, we have some businesses opening today, more are going to open Monday, and more the week after. One of the issues that I haven't seen my state address, and I don't think I've seen any state address so far, is like, what do you do with employees who, like, you're reopening businesses, you're bringing people back to work, but where's the childcare coming from, because there's no schools, there's no camps, there's no daycares, there's no nothing for people to put their kids. And so, like, I take that back. California, I saw this morning, Governor Newsom in California said that when California starts to reopen, he's going to make like temporary daycare centers available to hold up to 400 kids a piece, which seems to me like a human petri dish that I'm not sure.
Are we going to put masks on them too?
I don't know, but it's a legit question. And as this crisis goes on, so right now, FFCRA went into effect April 1. If someone started using expanded FMLA on day 1, that'll take them through like June 30. And so, it's an issue we may not have to deal with until July 1 in kind of the worst case scenario, but it's still an issue that's kind of looming out there. And it's one that I haven't seen anybody really give a good answer to yet in terms of what are employees supposed to do if they don't have childcare and they don't have paid leave available to them, and yet their employers expecting them to come to work. Are we just going to put more people on unemployment? I just haven't seen a really good answer or a really good solution around that yet.
Well, I think some of that is getting baked into the guidance that we're seeing from both state and federal, that, phase 1, whatever we're calling the return to work phase, in Pennsylvania, it's like the yellow light phase. In under the president's plan or guidelines, I think it is literally phase 1. New Jersey locally is still, they have 6 principles. I'm not really sure where the 6 principles, where this fits in, but a lot of it, we're still promoting telecommuting. And I think that's probably where this is going to end up. I mean, you can't telecommute and cut a lawn, or can't telecommute and serve, someone food at a restaurant. But a lot of people can telecommute. A lot of people with kids can telecommute. And I think that may be where we're headed, possibly through the summer. Maybe it just times out well because we're promoting social distancing even as we return to work. And businesses that have been relatively successful with the telecommute might continue to do that, at least summer, until we figure out what's going on in September or August, depending on maybe if you're in the South where the new school year starts up.
Yeah, which works well in an office environment. Like, well, I mean, you're remote all the time, but like for me, it works great for me because I have been working remotely since March. I'm going to continue to, and my firm is continuing to keep people remote at least through the month of May. But like in a manufacturing environment, I just have concerns that we're going to be pushing, because there isn't an adequate childcare solution, we're going to be pushing more people potentially to unemployment. And I just saw a comment come in. It's so challenging to telecommute with kids, though. Best of the bad options out there, but man, it's tough on parents. It is, because we're now, we're employees, we're parents, we're, if not teachers, at least teachers' aides, trying to kind of navigate our kids through the school day. There are no ideal solutions here at all, and I think we've all made the best as we can of a terrible situation. I just think that childcare component has to be part of any responsible return to work protocol, and I just haven't seen any state really address it yet, except for California, which seems to think we're going to throw everybody into these petri dishes of kid germs, and that's going to solve the problem. And I think it's going to create more problems themselves.
Yeah. I saw a question about, might as well address it here. Can a company receive PPP and use the payroll tax benefit for FFCRA? And then says in parentheses for different weeks. The answer is no. You can't apply PPP loan proceeds to pay out the FFCRA. Now, feasibly, you could do it for other forms of paid off, for other employee benefits, but you can't do it for FFCRA. That would effectively be a double dip. John, I was going to talk about one on my outline here, lingering issues, and I have one that I'd love to discuss, where I spent way too much time yesterday. And this is something, folks, that us DIRD employment lawyers have been debating, and that is, how do you as an employer run paid time off concurrently with expanded FMLA during the final 10 weeks of leave? And the way the regulation or temporary rule is set up, the way the frequently asked questions guidance are set up in question number 86, it led me to believe, and it led others to believe, that what you need to do if you're going to run an employee's bank of paid time off concurrently with their 2/3 pay under expanded FMLA is you effectively pay them 167% of their pay for each day that they miss. That is a full PTO day plus 2/3 pay. But not everyone agreed with my interpretation and others' interpretation. So I spent a good part yesterday talking to, I called 6 different DOL district offices to see if I could get an answer. And I can say this, I didn't get the straightest of answers. The feedback I got was that the field investigators are human like we are. This is a new law, and they're still kind of wrapping their hands and heads around it. But most everyone I spoke to said that what you do is you pay out 100% when you run concurrent. So it is just one day, one normal day. The most cogent answer, and that's not to say that the others were incoherent, but kind of the best answer I got was from a representative investigator in Philadelphia who told me that basically what you would do is you would charge one full PTO day if you're going to run concurrently, and you would get a 2/3 tax credit from the IRS at the end of the quarter, and that's basically it. This idea that there's something in the guidance that talks about reaching agreement to supplement pay for employees. So as long as you don't violate federal or state law, the employer or employee can agree to supplement an employee's 2/3 pay. And what she told me is that's a situation in which an employee either doesn't have any paid time off left or might have some paid time off that isn't designed to be used for expanded FMLA. So for example, if someone had, I don't know, bereavement leave or a personal sick day that you couldn't otherwise use to stay home and care for someone else, the employer and employee can agree to apply that time towards expanded FMLA to bring someone up to full pay for the day. Again, this isn't anything official. Please don't necessarily rely upon this as the gospel. But these are the explanations that I've gotten. So going forward, I guess it's 100% pay until someone says otherwise. Maybe the DOL will say otherwise. I don't know.
For what it's worth, I was Team Eric on 167%. That's the way I read the regulations and the FAQs. But I think this is probably the worst written part of the FFCRA, both from a statutory standpoint and from the regulatory standpoint. And when we classify sins in terms of sins of commission or sins of omission, I would put this in the latter, in that we had a statute enacting the first type of paid leave in the history of the United States of America that came together in 5 days, and then 124 pages of regulations that came together, in the span of a couple of weeks. And I think everybody in DC was scrambling to get this statute together, to get workers some benefits, and then to figure out what it all meant. And I think they did the best they could given the time they had. And this is just one of the issues that I don't think was sufficiently flushed out in the DOL's efforts to interpret the statute for employers.
Yeah, and leave it to nerds like us to kind of pick it apart and find all the little loopholes and things like that. So if anyone from the DOL is watching, Secretary Scalia, if you're watching this, we would politely and respectfully request that in the next round of updates to the FAQs, providing some actual examples of how something like concurrent paid leave works would be, thank you so much. John, we were talking a little bit earlier about return to work issues. And I know you've been blogging recently about what's been going on in Ohio with respect to face masks. And what is the latest in Ohio on face masks? Are they required? Are they recommended? Are they kind of sort of both? What's going on?
The latest in Ohio is that they are required for employees and a recommended best practice for everyone else. That if you are an employee at work, you are required to wear a mask at all times, subject to a couple of exceptions. Some could argue that maybe the exceptions swallow the rule in a lot of cases, but there's an exception for safety. There's an exception for effective communication between employees. There's an exception for employee medical issues. There's an exception for where otherwise superseded by a federal regulation or law. And there's an exception for employees that are working alone in an enclosed space. Like if you're in an office by yourself with the door closed, you don't need to keep a mask on. So, but at least as a default, masks are required for employees and recommended for everyone else. So non-employee visitors to a business, retail customers, etc., recommended but not required. I personally think it should be required for everybody because I think it's at least the science that I've seen suggests that if everybody wears a mask, you can bring the viral spread down to an effective rate of 0, which will put us in a great position, particularly if you combine it with things like good hand washing hygiene and sanitization efforts and social distancing. We can bring the spread of this virus down to 0. But people for whatever reason, people view this mask issue as a civil liberties issue. Like don't tell me I have to wear a mask when I'm in public, big government. And to me, I view it as a matter of courtesy that you wear the mask because you don't wear the mask to protect yourself from others' germs. You're wearing it to protect others from yours. And so I view it as a matter of kind of common courtesy and decency. And those that go out in public not wearing the masks, I look at them as I kind of walk past them in the store, my weekly sojourn to the grocery store, which is the most stressful part of my week now. The people that aren't wearing masks, I kind of look at them kind of side-eyed, like, you selfish person, how come you're not wearing a mask?
Are those the ones that are sampling the grapes?
Half bites and putting them back. I just and licking their fingers and touching the cards.
Mm-hmm.
I just don't get the backlash against it and how this all of a sudden become like the civil liberties issue that people are going to die on their sword for. But that's where we seem to be. But at least in Ohio now, for employees required and for customers recommended.
Yeah, the talk I've seen locally is, well, aside from telecommuting again, is face masks. Although I don't think we've gotten to that point yet where it's been, well, we don't know necessarily for the non-essential businesses whether they're going to have to wear masks. Otherwise, anyone else for essential businesses are wearing masks right now, but at non-essential businesses, it's to be determined. I think locally here, I'm licensed to practice. I'm sitting physically in Jersey, but I practice in Pennsylvania and New Jersey. Pennsylvania seems a little closer to returning work than does New Jersey. Jersey is one of the hardest hit states, mostly in the north, where you're just outside of New York City. Philadelphia was hit particularly too, but I think overall Pennsylvania is a little closer to returning to work. It sounds like we might even get some people returning to work maybe next week. I saw hints at that. We'll see what Governor Wolf says today, but looks like it's pretty close. On a related note, John, are you working with clients or on temperature checks and COVID-19 tests for non-essential businesses, for folks that are getting back to work? Are you working on protocols with them?
I have been, and at least again, what my state is requiring, we're not requiring temperature checks as a return to work condition. We are recommending them as a best practice, but Ohio is requiring self-assessments as a condition to employees returning to work. So people have to certify that I don't have a fever over 100.4, I don't have a cough, don't have shortness of breath, no headaches, no sore throats, all the symptoms that the CDC is listing for COVID-19. So you have to have some kind of self-assessment by the employee, not a temperature check. But I am working with businesses that can get the infrared scanning thermometers, or either have
like the ones like you use to the ones you use to test your meat roast, like
yeah. Yeah, so for those that have the thermometers or can get their hands on them, I'm working with them in terms of building protocols, in terms of how we're doing it. I did a webinar at noon this morning for an organization that we work with, and someone asked, how do we scan people's temperatures if we're supposed to maintain social distance of 6 feet? And I said, well, you either get really long arms, or there is a kind of a bit of common sense here. And obviously, unless you have arms that are 6 feet long, obviously you need to get closer than 6 feet to take someone's temperature. But we're going to be wearing gloves, we're going to be wearing face masks, and so we're going to put some basic safety protocols in place that will allow you to get within a distance to actually measure someone's temperature. And as the EEOC has said, because the pandemic is a direct threat, that all the typical rules we think of with medical exams and inquiries in the workplace are essentially kind of all systems go right now. So all those rules are out the window, at least so far as COVID-19 is concerned. So where you couldn't take a temperature before, the EEOC says you certainly can now, because you're trying to limit the direct threat from coming into your workplace.
Yeah, there's a question that just popped up about documentation on wellness checks and temperatures, and that's something that I've been wrestling with clients, not wrestling against them, but us wrestling together, on this issue, right? So on the one hand, John, as you were talking about, are we going to have people show up to the office or to the factory, queue up in line to get scanned before they come in? Like, that's one option. You literally have people show up, and then, heavens knows who's going to be the person who's responsible for holding the thermometer doing that. I don't know many people.
The person with the longest arms.
Right. So you go into HR and let's see who has the longest arms. I'm sure this is exactly what HR signed up for, to be taking temperatures in a COVID-19 pandemic. I would assume you probably want to have a third party come in and do it. But I think the better solution is you have employees self-assess at home. Now that opens up a Pandora's box of questions, like, are you going to pay for the thermometer, or is the employee going to pay for their own thermometer? How are you going to have them report it? Getting back to the question, right? Is someone going to kind of just call in and say, all clear, I don't have any symptoms today, all clear? Or is someone going to have to go onto the intranet or via an app and enter all the data? Okay, so then with the data, right? Is the company going to receive information about your temperature, about other physical conditions that you're suffering from, or are you just going to get the thumbs up or thumbs down? If getting the little individual pieces of data, like someone's temperature, like the fact that someone has a sore throat, that someone has a cough, what are you doing with that information? How are you protecting it? There are HIPAA rules. This is protected health information. So these are issues that I think a lot of employers are wrestling with. And I realize, to the person who just asked the question, I have probably created more questions than answers. Other than, for me, I'm thinking if it's manageable, I always take their temperature and affirm their wellness before they come to the office. I don't want to make them come out. I don't expose them to anyone. I'd rather just have them log on either on their phone or on the internet from home and self-certify. And if it's, they're all clear, then they can come into the office.
Yeah, I think that makes a lot of sense. Certainly, once you get into have employees fill out a piece of paper that says, my temperature today was 97.8, and I don't have a cough, and I'm breathing fine. You do run into very much more complex issues of what do we now do with this information? Because while potential HIPAA issues, because you have you're potentially collecting PHI, and then on top of that, even though the EEOC has said the health inquiry and health exam rules are out the window, the ADA's confidentiality rules certainly are. And so you would have to maintain the information in separate files and keep it confidential, and it becomes much more administratively burdensome at that point, to where if you can just, and I think you're probably getting to the same place if you just have employees either call into a hotline or going through an intranet or an app or something just to check the box today. I have self-assessed today and I have any COVID-19 symptoms versus, or even just it's an implied when you show up to, these are the rules, and by coming to work, you are certifying that you are free of any COVID-19 symptoms. Probably gets you to the same place, I would think.
Yeah. Yeah, so someone just asked, what would happen? What would the employer liability be if an employee self-certifies but isn't truthful? So they say that they're here, in fact, they've got a fever and they've got a cough and sore throat and all that stuff. I don't think there really is much employer liability at that point. I mean, once someone shows up to work and you can see all these symptoms manifesting themselves and you leave them in the workplace because, they self-certified, they're fine. I think that's a different story.
Very different issue.
Yeah.
But I mean, if you put the safety protocols in place, if an employee is going to lie to get around them because they want to come to work, there's not much you can. You can't guard it. You can't guard against the deceitful employee. All you can do is call them out on it when you discover that they were not being honest or if symptoms crop up during the day.
Yeah. I mean, here's someone who says, we have several employees who don't have a thermometer and ours haven't arrived yet. What then? I mean, I think these are exactly the issues that I don't know the answer to that question.
I don't either, because go on Amazon and search for thermometers. And good luck getting one delivered over the next 4 to 6 or 8 weeks.
Right. It's yeah. I mean, I think you encourage people to telecommute as much as you can. But if it's the same issue with having employees get COVID-19 tests, right? I mean, they're not, as far as I know, the COVID-19 test isn't like something I can just go to a corner drugstore and walk in and say, hey, give me a COVID-19 test. I don't think it's that easy.
No,
we're not there yet.
You need a doctor's script to get one. They're being given, being given on a very limited basis. So good luck getting one if you want one. And then the same, I've had questions come up in regards to antibody testing. Can we require employees to go get tested for COVID-19 antibodies and bring that certification into work that they have the antibodies and therefore they had the infection and have a resistance to it or are no longer contagious or whatever. And the reality is that the antibody tests around on the market nowadays are just not liable of anything. They are poorly manufactured. They are one of the businesses here locally that's offering them has a big disclaimer on their website that says that a positive antibody test is only indicative that you have antibody some strain of COVID something, and it cannot be relied on for you having actual antibodies of the COVID-19 strain that's causing all the issues now. So I am strongly counseling everybody about antibody testing not to use it right now. We have a much more reliable and readily available test that actually tells something useful.
Yeah, I mean, for that, I would just say CDC guidance, right? I mean, until some real authority tells us that antibody means something, I'm very reluctant to don the stethoscope and play the role of Eric Meyer, MD. So my best guess is good analysis, and I don't want to have to bill you 0.3 to have that phone conversation where I go, I don't know, depends.
There's an interesting comment here, Eric, about an attorney to be careful what we require from employees before they leave their house, end up leading to their commute time also being compensable. We all know California is a different world, which it is when it comes to law, but just to pass along that tidbit, which is a really interesting point. Yeah, California is the Disneyland of employment law, and it's hard to extrapolate what happens in California to the other 49 states, but it is a really issue if you are having employees give a certificate of their fitness to work before they leave their home. Are you now making their commute compensable?
Yeah, I'm not going to touch that California issue, although I have colleagues that could. But I'll say this generally: under the Fair Labor Standards Act, have you looked at that issue as to whether the time spent queuing up in a line to get your forehead zapped would be compensable time. I have.
I have too, and I think it probably is.
Oh, I was going to say no. Good, we can debate it. No,
okay,
I think no. I think it's not. I think it's not integral and indispensable to what you do on a day-to-day basis. There's actually the leading Supreme Court case is I forget the name of the contractor, but it involves Amazon. And
Bus versus Infinity.
Yeah, that's it.
Infinity Solutions, is that?
Yeah,
okay.
yeah, that's
Something
it.
like that.
And the court cites like a 1950s Department of Labor opinion letter in which the department concluded that standing in line at a fireworks factory to be checked to see whether you have anything flammable in your pockets is not integral and indispensable to what you do on a day-to-day basis. And I think, look, if I don't have to pay someone to stand in line to check for lighters and matches if they're walking to a fireworks factory, I don't think I have to pay someone to get their zapped before walking into the office every day.
Interesting. See, and I would say because we are classifying this pandemic as things like a direct threat, I would say that keeping coronavirus out of the workplace is necessary and indispensable. And so I actually come differently on the issue. I will also say, however, that whether the FLSA says you have to pay employees for their time queuing to get their temperature taken, I think as a matter of best practice, we should be doing it anyway. That if you're asking people to 6 feet apart and queue up in line for 10 or 15 minutes while they wait to get their temperature taken, I think that's time you should be paying them, regardless of what the bus case says or doesn't say about whether it's necessary and indispensable. But I think because we have this classified as a pandemic and the EEOC says it's a direct threat, and we're so concerned about limiting spread and keeping this out of the workplace, I would actually say this might be different than the flammable materials in your pocket analogy that the court relied on in Bust. But the hell do I know?
I'm fairly risk aggressive too when it comes to these things. That's why companies have EPLI insurance. So Mike Haberman, friend of both blogs, Mike Haberman asks, what can someone do if they have a true fear of coming to work, but their employer is requiring them to come to work? And this is a great segue into what I think is a really underrated part of this return to work, and that's FMLA. Classic FMLA. You know, we hear a lot of talk about ADA and interactive process and things like that. Someone is, let's say, immunocompromised, or they have a doctor's note, pretty easy answer is telecommuting. But FMLA leave, I think, is a really underrated part of coming back to work, because in that situation, if someone has a true fear or anxiety about coming back to work, they might have a serious health condition. And you might need to provide them with up to 12 weeks of FMLA leave, assuming they haven't used any of that 12 weeks of FMLA for, expanded FMLA or anything before COVID-19. What do you think, John?
That's a good point. Assuming it is a bona fide, legitimate, diagnosed mental health issue, if someone has a legitimate of leaving their home because of coronavirus, I think if they have the right documentation from a mental health professional that would qualify their absence under the FMLA, then an employer is going to have to consider, is likely going to have to grant in that case. Yeah, it's an issue I hadn't thought about before you just mentioned it, but I think it's something that employers need to be tuned out. I think the bigger question is, if you say employees on furlough end the furlough, come back to work starting on Monday, the employee says, I don't want to leave my home, I'm scared of coronavirus. Is enough information to trigger an obligation to send out the FMLA notices, or does the employee have to say, no, I have a diagnosed anxiety disorder that has been triggered by coronavirus, and I've been curled up in my bed under the sheets for the last 6 weeks, and I ain't leaving until it's over?
Yeah, I think it's probably somewhere between the former and the latter, closer to the latter. I think just I'm concerned about spreading it to, contracting coronavirus and giving it to my family. I don't think that smacks of serious health condition. But if someone says, yeah, I have a panic disorder, I have anxiety, I have PTSD, whatever, mental health issue, I'd send out paperwork. Let them get certified.
Yeah, and someone said, "What about ADA leave?" And that's true too. I mean, you do have, it may be the underlying mental health issue may also be an ADA protected disability for which an unpaid leave of absence might be a recommendation. But if you can qualify an FMLA covered absence, you might as well send the paperwork and run that FMLA and run those 12 weeks down while the employee is sitting at home. If you have to grant the leave as an accommodation under the ADA anyway.
Yeah, I mean, I'm a little more risk aggressive on ADA. I mean, just someone who has that kind of generalized fear, I don't think that's a disability, even though the bar is very low. But
Agreed.
Also, the question becomes, how can you do your job with or without a reasonable accommodation? What's unpaid leave going to do?
The unpaid leave might get you to a point where there's a vaccine or there's some other measures that will give the person, that will alleviate the person's. Let's say someone suffers from a diagnosed anxiety disorder, and there's a vaccine 90 days from now, which we know is not going to happen. But let's live in hypothetical land for a second. That unpaid leave of absence might be enough to bridge the gap where the kind of conditions existing out in the world will alleviate that anxiety to the point where the person will be able to get out of the covers and leave their home and come back to work.
All right. So let's switch gears a little bit, John. I want to talk about the types of lawsuits that might come up, COVID-19 related lawsuits after we start returning to work. And Law 360, shout out to them, shout out to Braden, who had an article in the April 29th edition, 5 types of suits employers are bracing for post-pandemic. And I want to run these by you, John, and let's decide whether they are like really, we're really bracing for these things, or whether this is not as bad as it seems. Timekeeping challenges under the Fair Labor Standards Act.
Huge freaking issue.
Okay.
Huge issue for remote workers.
Yeah.
Keep businesses that are not used to having employees work remotely. Employees that are not used to working remote, they're now working remotely around the clock, or at least 40 hours a week or more. I think it's going to be a huge issue that plaintiffs' lawyers are going to sink their teeth into. Apologize if there's any plaintiffs' lawyers on the Facebook Live today. I just called you all vampires, but sometimes I speak the truth. Huge plaintiffs' lawyers to sink their teeth into, because I can guarantee you that most employers out there have not implemented sufficient timekeeping best practices to capture every minute that an employee is on the clock and working remotely from home.
I'm optimistic that most people that are teleworking now are exempt anyway. Maybe that's some false optimism, so then the timekeeping issues wouldn't be as big of a deal. But sure, that doesn't eliminate everyone. And if we have non-exempts, businesses to be on top of this.
I think a lot of people that are working from home are exempt, but I think in an office environment, particularly, you have a lot of non-exempt, more small A administrative, not big A, FLSA administrative exempt, but small A administrative folks that are working from home for the first time, where this could present a huge issue for employers down the road in collective action, class action litigation.
All right. The next category of lawsuit is the FFCRA lawsuit. Whether it's the failure to provide the paid sick leave, it's miscalculating. How big of a concern, 110, do you think that is for employers?
It's probably a 7 or an 8. I think we've already seen two DOL enforcement actions, or two DOL investigations moments that the DOL has announced. FFCRA they were small dollar settlements. It was $1,200 for one, I think $2,800 for the other, for individual cases. But it shows that there are employers out there are either not understanding these issues or are not providing this leave. And on a bigger scale, I think probably are lots of employers out there that are either not doing this correctly or flat out ignoring the issue. And so I think it is, again, another area that the plaintiffs' bar are going to sink their teeth into as an area, particularly because these are going to be litigated under the FLSA or the FNLA. There will be attorney's fees that attach with it. And so I think it's going to be an area ripe for litigation down the road.
Yeah, I agree with you in that I don't know whether it's going to be the of claims or the size of each particular claim. Like maybe you'll have a collective action if some business is just not providing this for anyone, or they could be brought as individual claims, which will add up in terms of defense costs. But I think one of the other underrated aspects here, and you were touching upon it earlier, John, and I forget, someone commented about this on one of our LinkedIn posts, and that is when the DOL gets involved, they're not necessarily just going to look for FFCRA violations. I mean, once the DOL enters your front door, for other wage and hour violations, they may be looking for FMLA violations. They're looking at your record keeping. So this could open a Pandora's box into other larger FLSA and FMLA claims that have nothing to do with the Families First Coronavirus Response Act.
Yeah, because when they're coming in and they're saying we're investigating this employee, right? So we need all their pay records for the past 3 years, and then they're going to I mean, they can't ignore what they see. So if they see potential time violations or potential minimum wage violations or record keeping violations, they're going to have to add that to the investigation, and which then could cause them to expand the scope of the investigation beyond that one employee, but to all your employees. And it's like when OSHA comes in and OSHA says, we're here to investigate, there was an accident on this machine. We're here to investigate the accident, but let's look at the guarding on all of your machines in the work. Let's look at your confined spaces, and let's look at everything we can look at as we walk through your plant, or that's part of an emphasis program. It's the same thing. So what's in plain sight is in plain sight. And I firmly believe that because of how complicated the FLSA's regulations are, that any employment lawyer can walk into any work site and any employer in the U.S. and find an FLSA violation, just because the regs are just dense and complex and hard to. And so it's certainly an issue that employers need to be tuned into.
You firmly believe. Are you one of those people who put my client strenuously denies in your legal briefs? Do you write that?
No.
Okay.
Objection.
Yeah. Category number 3. I think this is the big one. Sections. Whether it's 360 writes it up as OSHA. I'm going to lump in whistleblower and wrongful discharge based on, working complaints about working conditions generally and people then getting fired. I think that's going to be the number one claim.
Huge. And let me take it one step further. It would not surprise me at all if coming out of this, labor unions and labor organizing has its son.
Mm-hmm.
Every employee in America right now is getting a crash course on how to organize, from the employees at Amazon and the employees at Tyson Foods and the employees at Whole Foods, people that are unhappy with the working conditions that they say they're being forced to work under, and are organized. Like today's May Day, and Amazon employees are walking off the job. Instacart people are walking off the job today. You see what's going on, and President Trump said, the meat processing plants aren't shutting down, and the Tyson Food employees are saying, try and force us to go back to work. We're not working unless we think it's safe. So and granted, Tyson, the meatpacking employees are already collectively bargained, but every employee in America is getting a crash on how to organize and add protected concerted activity looks like. And so it would not surprise me in the coming this union organizing has a moment in the sun. Yeah,
and another thing, if you're one of those fortunate employers that got a PPP loan, read the fine print. You just agreed to a neutrality pact. So if you just want to organize, what a neutrality act is you're not allowed to come out against the union. You've got to remain neutral as the employer. So we'll see what happens there. The next category is, and I think this is a 1 or a 2. Mass layoffs inviting, not for failing to provide a notice of a mass layoff for WARN. I think this is a 1 or a 2.
Yeah, I would agree. And the DOL put out an FAQ, I think yesterday, on WARN Act issues with COVID-19. And one of the questions was, does this qualify as
unforeseen business circumstances?
Thank you. Unforeseen business circumstance to delay, WARN notices or to excuse an untimely WARN notice. And they basically cited the regulations and then basically said, talk to your lawyer. That's what essentially they said. But I believe it is. I've had a couple of clients that unfortunately have had to issue WARN notices. They did not wait the 60 days. They issued them as soon as they could. And it was actually contemporaneously with, a day or two after a mass layoff or plant closure. And it is what it is. I see very little risk here under the WARN Act. I agree.
Yeah, as long as you do provide notice.
Right.
So, I mean, concurrently.
Right. It's not an excuse for providing the notice at all. It's just an excuse from giving 60 days notice.
Yeah. And the last issue that Braden Campbell highlighted, and we talked about already, is ADA. So I want to put another letter into that and your take on ADEA. And specifically, John, the risks that employers run of stereotyping and saying, if you're older, we want you to stay home. If you're pregnant, we want you to stay home. That is serious low-hanging fruit for the EEOC, right?
Big time low-hanging fruit. And it's something employers need to be very careful about. We as employers don't get to be, master protector of our employees and act what we think is in their best interest. It's their bodies. It's their decision as to what to do and what's in their best interest. And so we can't say, if you're immunocompromised, stay home. Now, there may be a state shelter in place, stay-at-home order that says the opposite. Ohio stay-at-home order, for example, says if you're over 65 or underlying health condition, you're not supposed to leave your home, except medical treatment. So there might be a state order that says otherwise, but an employer shouldn't be in a position of saying, you're 65, don't come to work. Or you, if you're immunocompromised, self-identify and don't come to work. If you're diabetic, let us know and don't come to work. Yeah, it's a big time low-hanging fruit for the EEOC. And I'll put another category in there, which is working parents. I think the EEOC has, fought caregiver discrimination, and while caregiver isn't a category of discrimination that's a protected class, there's classes that give rise to caregiver rights or parental rights, like sex, like disability. And so we need to be careful that we are not treating parents that have kids at home that need to give them some TLC during the workday, that we're not treating them more harshly than other similarly situated employees.
Have you, speaking of that, getting all the way back to where we started, the FFCRA, just anecdotally, how many of your clients are providing intermittent leave? How many have said, we're not going to provide it? Because it is the employer option.
Yeah, I have not yet had an employer say we're not going to provide it. What my clients are doing, what I'm encouraging, is kind of get around the leave issue completely by just, if people are working from home, there is no reason to limit them to a 9-to-5 workday unless you have to have them available during those hours for some reason. But if someone has to be in a meeting or whatever, that's a different story. But for the most part, if people are at home and working on their stuff, there's no reason why you can't, and the FFCRA allows it, and the DOL in the ranks encourages it to say, all right, you want to be off work between 9 and 3 because you want to help with your kids' schooling, then your work hours are 7 to 9 and 7 to 6:30 to 8:30 and 3:30 to 9, 3:30 to 9:30 or whatever, however the math works out. And you just build work schedules that about the time that employees have childcare responsibilities, and you're letting them fill their work time in other hours to get their work done. And there you avoid the whole FFCRA and intermittent issue.
All right. Should we do a couple of questions?
Sure.
I'm going to just over to the questions that are being asked today. We'll give folks who attended the preference over the folks who submitted them in advance. I'm looking at a question right here that has been asked a couple times. I see a couple thumbs up. What if an employee has a family member at home who is immunocompromised and they don't want to come in out of fear of exposing that family member? What do you think, John?
It's a great question. So associational discrimination is the ADA prohibits discrimination on the basis of one's association with someone with a disability, but there's no reasonable accommodation requirement under the ADA to accommodate someone who's associated with someone with a disability. So in that case, the employer wouldn't have an ADA obligation to grant the time off. There may be an FMLA accommodation, or there may be FMLA that might be triggered if the immunocompromised person has a serious health condition that you need time to care for that person. So that's a possibility.
Could be some PSL there too. There could be some paid sick leave there too, but that's only going to be 2 weeks.
Right.
Yeah. Let's see what other questions we have. Here's a question. What about when staff leave for vacation in June and July out of state? What should you do when they come back to work? I've seen some people saying they're going to make their staff quarantine for 2 weeks. Can we do that, or will we just see this as this goes on with travel restrictions? So,
who the hell is taking vacation right now? Where are people going?
Not on cruises.
That's what I want to know.
But I mean, some of the CDC guidance is that if you've been traveling, especially internationally, that you've got to that you certify that you haven't been traveling internationally for the past couple weeks before you come back to work. I was just helping out a client in the Midwest today, where I was looking over a stay-at-home order, and that's part of the certification that the state wants essential workers to certify to, that they haven't been traveling out of state before they come back to work. So yeah, I mean, I think we're gonna get a lot more guidance between now and June and July. Yeah, potentially if people are world traveling, especially in places like, I don't know, I mean, it was Spain and China and France and Italy, that we might want them to spend a few extra days home before they come back to work.
Yeah, Ohio's stay-at-home order requires a 14-day quarantine if you traveled out, if you return to Ohio and from traveling out of state. Mm-hmm. So there's an exception if you work across lines and routinely travel out of state for work purposes. So if you live on the border and your job across state lines, there's an exception. But if you travel out of state and come back into state, you're supposed to be quarantined for 14 days under our stay-at-home order. And I would recommend that as a best practice. I'd also recommend, I've recommended clients, at least in the short term, and I don't know where we're going to be in June or July, but at least now, that travel won't happen, that it's mission critical travel only for business purposes, that employees are required to travel for work are quarantined for 14 days upon their return, and that employees not take vacations. And that if they take vacations, you can't stop somebody. I mean, you can deny paid time off, but I guess maybe you declare them AWOL if they just don't come for 14 days or a week or whatever. But I've told people, I've recommended to clients that if they're taking vacations right now where they're traveling, that not be paid time. So
yeah, I think you talk about the rise of organized labor. This also might be part of the demise of those unlimited PTO policies.
Yeah, no kidding. No And Eric, have you had any clients with unlimited PTO and have had to deal with that with the FFCRA in terms of concurrent leave issues?
I haven't encountered that issue yet.
Me neither.
Yeah, and I know clients have them, but maybe these are clients with over 500 employees. I don't know.
Right.
We are at the hour mark. I want to be respectful of everyone's time on a Friday afternoon. Well, I guess the U.S. Virgin Islands is only 1 hour ahead, but it's 5 o'clock somewhere, and some people might be treating it as 5 o'clock, and otherwise might have things to do before 5 o'clock. So, why don't we wrap this here? I want to thank everyone for coming out and attending today. Tell your friends if they missed it that they missed it. Nah, it's okay. We've recorded this. I'll post it on YouTube, so you guys can go back and check it out later on. Most of all, I want to thank my extra special guest, Jon Hyman. Jon, thanks for doing this. How did you like your first Facebook Live?
I loved it, man. Thank you so much. It was good to see you as always, and I really appreciate having me. And and keep posting the rest.
Okay, I don't know that I have any left in my arsenal. This is kind of out of desperation that I've resorted to mixing flour and baking soda and that kind of stuff. I mean, I really didn't know much about this beforehand.
So
I just knew about it small hourly.
So the Eric Meyer Cooks Facebook live stream is not going to happen then?
No, sorry.
Because I'm tuning back in for that for sure.
Yeah, that'll be great. It'll just be me cursing for an hour. All right, folks, have a great day. Enjoy your weekend, and I'm sure we'll do one of these soon enough again. Thanks a lot. Bye. All right, Jon.